Dear students, Namaskar. Today I'm going to discuss another important provision of Constitution that relates to Article 20 of the Constitution. Article 20 makes the provision for protection in respect of conviction for offences. Article 20 has three clauses. Each of these three clauses gives protection in respect of convictions for crimes. Article 20, Clause 1 spells out the provision against retrospective penal laws. It gives protection against the retrospective criminal laws or penal laws. A legislature has the authority, as all of you know, that legislature has the authority to enact the law or to make the laws. Such laws may be given effect from the date interior to its making. From the date of interior to its making means that in future, from the date of commencement, it can be given effect, but not retrospectively. So, an act which operates to cover past transactions as called retroactive or retrospective laws cannot be applied. Even tax laws may be, that even tax laws may be retrospectively, but the article, the article prohibits regarding the application of criminal laws retrospectively. But uh, but the civil law, or we can say tax laws, can be enforced retrospectively. Article Article 20, Clause 1, which says, but the Article 20, Clause 1 lays down two types of limitation on the legislature, either it's the central legislature or the state legislature. Here are the two types of limitations which has been envisaged by Article 20 Clause 1 of the Constitution. First, prohibition against enacting ex post facto penal laws. Ex post facto penal laws means that criminal laws. And in other words, if an act or omission was innocent when done, the legislature cannot make a law which declares such act or omission a crime. Means that in case if 10 years back some kind of act or omission has been considered as innocent act, then from today it cannot be enforced, or today it cannot be enforced retrospectively, retrospectively from the uh, uh, 10 years, from the 10 years back, we can say. But it can be enforced from today and onwards, prospectively, not retrospectively. So the legislature cannot make a law which provides for punishment of acts or omission which were committed prior to the date when the act came into force. If, for example, if bringing gold in India was never an offense, and the law is made in 1970, making import gold into India an offense. and applying that the same law from 1960 onwards, then such law is retrospective law. Such law is retroactive laws or retrospective laws, and retrospective in criminal laws not permitted by constitution or not permitted by article 20 clause 1, or it has been prohibited uh, by article 20 clause 1 of the constitution. Why? Because in short we can say that law new law cannot punish an old act. New law cannot punish an old act. Only the new law can punish a new act, not a old act, which has been remained as a innocent act, which has never been in past never been declared as an offense or as an crime. So an act which is not an offense on the date of commission cannot be made on offense on a subsequent date. Second part of Article 20 Clause 1, that a law cannot aggravate the crime. A law cannot change the punishment and make it greater and it apply it to the previous offense. Means that greater penalty, greater punishment cannot be applied, cannot be enforced retrospectively. So the new punishment, if it is greater, may be applied only for future, only from the future date, or you can say from the future uh, acts or omissions. For example, A commits, that in one case it was the case of very famous case. It was the case of Kedarnath versus state of West Bengal. Uh, A commits an offense in 1970. The offense is punishable with imprisonment of 3 years. But in 1972, the legislature amended the law and increased the punishment up to 7 years or to 7 years. The revised punishment cannot be inflicted on it because the offense was committed before the date of the passing of act, or uh, the uh, act was committed or offense was committed from the uh, before the date of the passing of act or amending the act. So that's why Article 20 Clause 1 does not permit retrospective application of increased uh, punishment also, or penalty also. So the provision does not apply to change in procedural laws. Means that all of you know that there are two types of the criminal laws. Uh, one is the substantive laws, and another is the criminal laws. And here, the provision is not applicable to the procedural laws. A person does not have the fundamental rights or rights to be tried by a particular procedure, because if the circumstances demands, then the person accused can be tried by the special procedure, special procedure of law. So the accused may take the benefit of reduction in benefit, or reduction in punishment only, and you know that Article 20 Clause 1 not only prohibits the legislature from enacting ex post facto laws, depriving a person of the protection given by this article, but it also says that, or it also lays down that no person shall be convicted of an offense. This indicates that courts too are prohibited. Courts too are forbidden to pronounce conviction on the basis of a law violating of two protections set out in Article 20 Clause 1, means that enhanced uh, that the new law cannot be punished for old act by the courts, and enhanced punishment or penalty cannot be enforced by the courts because of the provision of Article 20 Clause 1 of the Constitution. Now, Article 20 Clause 1, which talks about the few case laws also, we can cite for the sake of the academic discussion, that it's in one case it was the case of uh, Mohanlal versus State of Rajasthan, and it was the case of 2015. Here the accused, a night chokidar, was convicted for the offence under Section 18 of NDPS Act and Section 457 and 388 of Indian Penal Code for commission a theft of 10 kgs and 420 grams opium and some other articles from Malkhana on 13th November 1985. The accused contention, he argued, the accused contention inter alia in appeal was that incident had been occurred on 12th or 30th November 1985, whereas the NDPS Act came into force only on 14th of November 1985, and therefore the offence was punishable under Opium Act 1978 and not under Section 18 of NDPS Act. The High Court and Supreme Court both dismissed the appeal dismissed the appeal, and here the Supreme Court held that held him guilty and uh, held him guilty under Section 18 of NDPS Act. He had uh, so, because he was in possession, he was in possession of bent substance on the date of enforcement of the act. So he had both the corpus and animus, which were necessary for possession under the law. So Article 20, Clause 1 was held to be not applicable because the actus of possession was not punishable with retrospective effect. So the punishment was for possession of the prohibited articles on or after particular date on the enactment of statute. It was one uh, case which was related to Article 20, Clause 1. Here, another most important aspect of Article 20, Clause 1, that the beneficial provisions, means that both the accused beneficial provisions can be extended in favor of accused, even retrospectively. Here, but the accused can take advantage of beneficial provision of the law retrospectively or we can say, take the benefit of ex post facto laws. The rule of beneficial construction requires that ex post facto laws should be applied to mitigate the rigorous to mitigate the rigorous or reducing the sentence of the previous law on the same subject. So such a law is not affected by Article 20 Clause 1. So the principle is uh, based both on sound reasons and common sense. In one case, it was the case of T. Brahl versus Henry N. Hoy, which was the case of 1983. In this case, a complaint was lodged against the respondent under section 16 clause 1, subclause A, read with section 7 of the Prevention of Food Adulteration Act as amended by Amending Act of 1973. Uh, on the date of commission of the alleged offence, on August 16, 1975, the law in force in state of West Bengal was the amendment which provided that such an offence would be punishable with imprisonment for life. On April 1st, 1976, the enacted Prevention of Food Adulteration Act uh, was amended in 1976, and now it's reduced the maximum punishment of life imprisonment as uh, um, as provided by the earlier law. No, that now it reduced to 3 years imprisonment. So it was held that the accused could take the benefit, could take the advantage of reduced punishment. In another case also, it was the case of Ratan Lal versus State of Punjab. A boy of 16 years of age was convicted for committing an offence of house trespass and outraging the modesty of a girl. Also, outraged the modesty of a girl of 7 years age. And the magistrate sentenced him for 6 months rigorous imprisonment and also imposed fine. But after the judgment of the magistrate, the Probation of Offenders Act of 1958 came into force, and it provided that a person below 21 years age should not should not only be sentenced to imprisonment. Now, the Supreme Court, by majority 2 to 1, held that the rule of beneficial interpretation required that ex post facto laws or retrospective laws could be applied to reduce the punishments. So, an ex post facto laws which is beneficial to the accused is not prohibited by Article 20, Clause 1 of the Constitution. Now, the next principle next principle uh, which talks about that the next principle of Article 20, which is to be covered under the Article 20 Clause 2. It talks about the principle of double jeopardy. Here, Article 20 Clause 2 states that no person shall be prosecuted and punished for the same offense more than once. This embodies the common law maxim. This principle has been taken from the common law. And what common law maxim says that nemo debit vis vixari. Nemo debit vis vixari. What does it mean? That no man shall be put twice in peril for the same offense. Means that no person shall be put in serious and immediate danger for the same offense. Means twicely. for the same offense twicely. Uh, in case if he has been prosecuted and convicted for that offense, then he cannot be prosecuted and convicted second time, because it is prohibited by the principle of double jeopardy. If the US Constitution contains the provisions that no person shall be twice put in jeopardy of life and limb. This is commonly called double jeopardy. So, the double jeopardy has two aspects. First, auter fois convict. Second, auter fois acquit. And the plea of auter fois convict avers that or asserts that the, the principle of auter fois convict asserts that the defendant has been previously convicted in respect of same offense, and that's why it is prohibited. And the auter fois acquit is the plea that the accused has been acquitted on the charge for the same offense for which he is being acquitted. The Constitution protects a person from prosecuted and convicted more than once for the same offense, and does not include auter fois acquit. So it is, we can say that it is narrower than the American Constitution or than the American doctrine of double jeopardy, because the protection against auter fois acquit is to be found in this principle of auter fois acquit is to be found in section 300 of CRPC 1973, and it is a statutory right. It is not a your constitutional right, like uh, like under article, you could say 20 uh, clause 2. And the words prosecuted and punished, prosecuted and convicted or punished, uh, point out that the proceedings must be before a court or a judicial tribunal. A person who has been fined under Customs Act still be prosecuted under the FERA, means Foreign Exchange Regulation Act, because the Customs Authority is not a court. An inquiry and subsequent dismissal, that in one case it was the case of Venkataraman versus Union of India, which has been decided in 1954. And what held in that case, that an inquiry and subsequent dismissal of a government servant is no bar to prosecution for an offence under the Prevention of Corruption Act. Means that in case if he was dismissed from the service, that was because of the departmental inquiry, department proceedings, and it was the disciplinary authority which had taken the action of dismissal against him. But now, Article 20, Clause 2 does not prohibit that that there could be the starting of prosecution under corruption laws or under IPC or prevention of corruption laws. So the inquiry is not a prosecution, because by the court, and disciplinary action is not a punishment given by the court. So what is essential, that the words prosecuted and punished, only the benefit, only the fundamental rights is available under Article 20 Clause 2, that uh, the person must be prosecuted and punished out for the proceeding must be before a court by, must be before a court, means that the prosecution or the trial must be before the court, and the conviction or the punishment must be awarded by the court or the uh, judicial tribunal, not by other than courts. And in case, as we discussed, that in case if someone has been uh, dismissed in departmental inquiries or in departmental proceedings, then it is not prohibited. It is not prohibited that he could not be again prosecuted and convicted under uh, corruption laws or Prevention of Corruption Act. The Constitution prohibits double punishment for the same offense, or for the same offense. Conviction for one offense does not bar subsequent trial and conviction for another offense. So, if the and same act constitutes a offenses under different sections of acts, the Constitution does not bar separate trial and punishment. And here you can cite a very good and current example, or we can say which has been remained in news. It's the case of uh, it's the case of state of Jharkhand versus Lalu Prasad. As all of you know, that this case has been remained in news. That the accused persons were convicted in one of the criminal cases arising out of case known as fodder scheme, and under section 120B, 409, 420, 467, 468, 471, sections 477A of IPC, for being involved in a large scale of defalcation of public funds, fraudulent transactions, and fabrication of accounts in animal husbandry department of the state. So the accused took the uh, took the took the defense that once they were punished for a single journal conspiracy with respect of defalcation at various or different treasuries, they could not be punished for the same offense. The court held that since each defalcation or grabbing the money constituted independent offense, as offenses were committed at different places by different accused persons at different periods, resulting into various offenses. So, to be dealt in separate trials, the doctrine of double jeopardy was held not to be applied. So, it would be question of fact in each case, and question of fact in the each case, and there was no question of protection under double jeopardy or under uh, Article 20, Clause 2 of the Constitution. Here, uh, the principle of res judicata. Res judicata means that as the things has already been decided. So the principle embodied under section 11 of CPC. Res judicata rests on the principles that where an issue of fact has been tried by a court on a former occasion, the finding is final and binding on both the parties and cannot be raised again. So the principle is applicable to both civil and criminal trials. So since the doctrine rests on the identity of issues at the two trials. It is known as the doctrine of issue estoppel, or we can say the principle of issue estoppel, also known as cause of action estoppel, is different from the principle of double jeopardy or atrofos uh, equit as embodied under section 300 clause 2 of CRPC. The principle of issue estoppel applies where an issue of fact was tried by the competent court and finding was given in the favor of accused, which would operate an which would operate an estoppel which would operate an estoppel or res judicata against the prosecution. So it would not bar the trials it would not bar the trial or conviction of the accused for the different or distinct offense. So it would only prohibit it only uh, precludes preclude it only precludes the reception of evidence that will disturb the findings of fact, even for different offense which might be permitted by section 300 clause 2 of CRPC. The rule of issue estoppel prevents the relitigations of an issue which has been determined in a criminal trial between the parties. So the issue estoppel does not bar second proceedings but merely ex estoppel estoppel qua prior findings. Now, the next important provision which talks about that the provision against self-incrimination, that is the that is to be the prohibition against self-discrimination, which is covered, which is falls under Article 20, Clause 3 of the Constitution. Here, the Clause 3 of Article 20 is an important, or it is very important because it is an attempt to prevent a torture of accused by investigating agencies or by investigating authorities for the purpose of extracting the confession from him. In 18th century in England and even in 20th century in communist Russia, Nazi Germany, and many other countries, torture was a legal proceedings, or torture was a legal procedure. The but the uh, but the Universal Declaration of Human Rights proclaims that as per Article 5 of the UD, uh, um, um, as per Article 5 of the UDHR, that no one shall be subjected to torture or to cruel or inhuman or degrading treatment or punishment, as it has been prohibited uh, by Article 5 of the UDHR. So this clause provides immunity. This clause of UDHR provides immunity to a person who is accused of an offense. Means that it is a protection to an accused of offense. Second, it gives protection against being compelled to be witness. Means that he cannot compelled, he cannot forced to become witness against himself, and as well as he is also prohibited, or that he talks against that being compelled to be a witness, that against himself also and against others also. So this immunity is available only to a person who is accused of an offense. It can be claimed by natural persons as well as by corporations, etc. So the protection is confined to a criminal proceedings before a court of law or judicial tribunal. So it does not extend to civil proceedings or such proceedings which are not of a criminal nature. For example, under Custom Act or under Custom Act or FIRA regulations, uh, regulations, which that under Custom Act, yes, sorry, it is the immunity is available only to the person who is accused of an offense, and it has been settled in one case. It was the case of MP Sharma versus Satish Chandra, which was decided in 1954, that the immunity is available only to a person who is accused of offense, uh, and it can be claimed by a natural person as well as by corporations. The protection is confined to the criminal proceedings before a court of law or a judicial tribunal. It does not extend to the civil proceedings or such proceedings which are not of the criminal nature. For example, under the Customs Act or FIRA Act. So, in these proceedings, a person cannot refuse to answer on the ground that it might incriminate him, because all those are not in the nature of criminal proceedings. So, there he could not seek the protection uh, of Article 20 Clause 3. So, notice, or in another case, it was the Delhi Judicial Services Association versus State of Gujarat, uh, 1991. In this case, notice or pendency of contempt proceedings do not attract Article 20 Clause 3. So the contemptor are not accused of an offense. Contempt proceedings are not in the nature of criminal proceedings for an offense, because sometimes what happened, that in case if he's because sometimes ultimately the result may not be a conviction, because in case if he is going to seek apology, then and apology is going to be considered by the court, then the both condition that he ought to be prosecuted and convicted. So here he has not been convicted, and in case in that those circumstances he is not been convicted, and apology is to be accepted, then in that case we can say the uh, con- um contemner or contemner are not accused of an offense. The protection is against compulsion to be a witness. So the uh, courts, in this case, in one case, it was the case of State of Bombay versus Karthi Kalu, which was decided in 1961. Here, the expression covers oral evidence and written statements conveying the accused person's personal knowledge relating to the charge against him. So means that he cannot be forced. He cannot be forced to give any kind of oral evidence or written statements conveying the person's personal uh, knowledge relating to the charge against him. But he may be compelled to produce a material object or to give specimen writings, specimen signatures or fingerprints, etc. So, if an accused voluntarily make a confession or make a incriminating statement, then it can be used against him, because here the incriminating statement has been given by the accused voluntarily, not involuntarily, because he was not forced by any investigating agency or investigating authority. Now, uh, little bit we will discuss this article in more detail uh, with regards to the cases, or with regard to that compulsion to give is evidence against himself. So here the protection under Article 20 Clause 3 available only against the compulsion of accused to give evidence against himself, but left himself he may voluntarily, as we discussed, that he may waive this condition, and in case if he is going to give voluntarily statement against him or incriminating statement against him, then it is not prohibited under Article 20 Clause 3. So to attack the prosecution, to attract the protection under Article 20 Clause 3, it must be shown that the accused was compelled to make the statement likely to be incriminative of himself. And compulsion means duress, which includes threatening, beating, imprisoning of his wife, of his parents, or of his children, etc. So that's where the accused makes a confession without any inducement, without any threat, without any promise. Then Article 20 Clause 3 does not apply. Here, in one case, it was the case of Muhammad Dastgir versus State of Madras. The case Muhammad Dastgir versus State of Madras. It was the case of 1960. The appellant went to the bungalow of DSP to offer him bribe. In a closed envelope, the police officer, on opening it, found that the envelope had currency notes. He threw it. He threw it at the face of appellant. Then appellant uh, took it. Thereafter, the police officer asked the appellant to hand over the envelope containing the currency notes. The appellant took out a few currency notes, or some currency notes, from his pockets and placed it on the table, which was seized by the police officer or deputy superintendent of police. The appellant contended in the appeal before the Supreme Court that the currency notes should not be produced in evidence, as he was compelled by the police officer to give it to him. The court, or Supreme Court, held that the accused was not compelled to produce the notes, as no duress was applied by the police officer to produce the notes. Moreover, the appellant was not an accused. He was not an accused at the time the currency notes were seized from him. So that's why the protection of Article 20 Clause 3 was not extended to the accused in this particular case because that he was not accused at the at that very time, because the appellant was not an accused at the time of currency notes were seized from him. In another case, it was the case of Yasuf Ali. What's the state of Maharashtra? It's the case of 1968, and here a tape recorded tape recorded statement made by the accused, though made without knowledge of the accused, but without force or without operation, was held to be admissible in evidence. In another case, V.S. Kuttan Pillai versus Ramkishan, the court held that the search of premises occupied or in possession of the person accused of an offense or seizure of anything from there was not violation of Article 20, Clause 3 of the Constitution. So, if any documents is recorded as a result of search and seizure, it can be produced in courts as an evidence against the accused, as he is not compelled to give witness against himself, and that cannot be compelled to give witness against himself. In another case, it was the case of 2007, Amrit Singh versus State of Punjab. It has been held that asking an accused of his here for purpose of identification amounts to testimonial compulsion. Means that in case if the accused is going to be asked to give his here for to give his here for the purpose of DNA, etc., and which can be used against himself. So the accused has right to refuse to give the specimen of his here for purpose of identification, because it's the duty to prove the duty of the prosecution to prove the case. He cannot compel or force the accused to become witness against himself. So he cannot be made witness against himself in view of Article 20, Clause 3 of the Constitution. Now, uh, now you know that in the era of scientific age, another new technologies are going to be applied on the accused for the purpose of investigation of a crime or the purpose of investigation of an offense. For example, uh, narco analysis, polygraph, polygraphy, and brain finger printing test of accused. And you know that all these questions were raised in one landmark decision, and the Supreme Court has decided the or laid down the guideline in relation to all these scientific technology or all these tests, whether all these tests were permissible or not permissible, and whether the accused could have protection against all these techniques under Article 20, Clause 3 of the Constitution. And these issues were raised in one landmark case. It was the case of Selvi versus State of Karnataka. And this case was decided in 2010. Here, the accused uh, had challenged the validity of certain scientific techniques, namely narcoanalysis, polygraphy, and brain fingerprintings tests without their consent, and they argued that it was the violative of Article 20, Clause 3 of the Constitution, and they argued that these scientific uh, techniques were softer alternative. What was the contention given by the uh, counsel for the accused? That all these are the softer uh, alternative to the uh, regrettable use of third degree methods by investigators and violated, violated rights against self-incrimination in Article 20, Clause 3 of the Constitution. The state argued that it was desirable that crime should be efficiently investigated, particularly the sex crimes, as ordinary methods were not helpful in these cases. So the issue was between what were the issues? That there were issue between the efficient investigation and preservation of individual liberty. And a three bench of Supreme Court, three judges bench of Supreme Court unanimously held that these tests are testimonial compulsions and are prohibited by Article 20, Clause 3 of the Constitution. And these tests do not fall within the scope of expression. Such other tests in explanation of Section 53 of CRPC. The protection self-incrimination is available at the stage of investigation also, and it is also available to the witness also. So first of all, what is happened in narco analysis test, as a drug is given to the accused so that he can divulge important information, so that he could make known, he could make information or make known the information related to which are very privately and which are very sensitive information also. So one drug is to be injected, or the drug is to be given to the accused for knowing the very private and sensitive information related to the accused. And the that drug is the sodium penta sodium pentothal, uh, used for used or introduced as a general anesthesia in surgical operation. And the polygraphy and brain fingerprinting test is also known as the wave test. Electric waves are electric waves are introduced in the mind of the accused, and the compulsory administration of the narcoanalysis narcoanalysis techniques constitutes the cruel, inhuman, or degrading treatment. And Article 21 of the Constitution uh, disapproves of involuntary testimony, irrespective of the nature and degree of uh, coercion, threats, fraud, or inducement used to elicit elicit the evidence. And the popular means of the terms such as torture and cruel, inhuman, or degrading treatment are associated with gory images of blood letting and broken bones. A forcible invasion into a person's mental process is uh, also an affront to human dignity and liberty, often with grave and long and lasting consequences. So the in, and so the conventions, or your international convention, though not ratified by the parliament, are persuasive values since they represent an involving international consensus on the issue as conventions against torture, other cruel, inhuman, and degrading treatment or punishment of 1984. So, regarding the contention raised by the respondents that the compelling interests demands such techniques for the investigation of crimes in future in future, but the court held that it is the function of the legislature. Means that it's the function of the legislature to consider and make proper law on the issue. But if such matter comes before the shall interpret the uh, court shall interpret the mandate of constitution or mandate of constitutional provision available to the citizens and apply in their favor. So the court laid down the following guidelines for these tests. First, the no lie detector test should be administered except on the basis of consent of the accused. An option should be given to the accused whether he wishes to avail such test or not. Second, if the accused volunteers for a lie detector test, he should be given access to a lawyer, and physical, emotional, and legal implication uh, of such tests should be explained to him by the police officer, and all these repercussions, all these implications should also be explained by the police officer to the lawyer of the accused also. The consent should be recorded by a judicial magistrate. Means that it should not be recorded by himself, a police officer. So, and next, the during the hearing before the magistrate, the person alleged to have agreed should be duly represented by a lawyer. The next, at the hearing of the petition in question, also be told in clear terms that the statement that if made shall not be confidential statement to the magistrate, but will have the statement made to the police also. So the magistrate shall consider all factors relating to the detention, including the length of detention and nature of interrogation also. So the actual recording of the lie detector uh, shall be done by an independent agency, for such as hospital, and the conducted in the presence of lawyer of the accused. A full medical and factual narration of the manner of the information received must be taken on record. So, in this, landmark decision, the Supreme Court has laid down all these few important guidelines regarding conducting all these tests. Either it is narco analysis or polygraphy and brain finger printing tests of accused. Dear friends, it's all related to related to Article 20 of the Constitution, which talks that protection in respect of convictions for offences. Thank you, and we'll continue our next lecture. We'll meet soon, and in case again, if you are having any doubts or query, do kindly ask Mr. Bhan or Mr. Abhishek Agarwal to have a meeting on Zoom or on video conference. Thank you. Thank you.